Hello friends. So today we will be speaking on Hindu Adoption and Maintenance Act 1950. In this video lecture, I shall cover section 11 to section 17. So myself, Dr. Mrs. Sonali J. Gaikwad, Assistant Professor, DGB Dayanand Law College, Sholapur. So to begin with, So section 11, other conditions of a valid adoption. What does this section specify? It provides for certain basic conditions to be taken into consideration by the person who wants to take in adoption. In every adoption, the following conditions must be complied with. Subsection 1 says that if an adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son, son's son, or son's son, whether by legitimate blood relationship or by adoption, living at the time of adoption. That is, the mother or the father who wants to take in adoption, they should not have their own son, son's son, or son's son. That is, their own son, grandson, and great grandson. Subsection 2 says that if the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter, whether by legitimate blood relationship or by adoption, living at the time of adoption. So, subsection 1 deals with son, subsection 2 deals with daughter who are to be taken in adoption. Subsection 3 says that if the adoption is by a male and the person to be adopted is a female, then the adoptive father is at least 21 years older than the person to be adopted. Next is if the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. Subsection 5 says that the same child may not be adopted simultaneously by two or more persons. And subsection 6 says that the child to be adopted must be actually given and taken in adoption by the parents or guardians concerned or under their authority with intention to transfer the child from the family of its birth, or in case of an abandoned child or a child whose parentage is not known, from the place or the family where it has to be brought up to the family of its adoption. So the adoption must be actually, that is, the child must be actually given from the natural family where he is born to the adoptive family, and there has to be an intention that the child has to be given in adoption, provided that the performance of the homa shall not be essential to the validation of an adoption. Next slide says that section 12 that deals with effects of adoption. Now, what are the basic effects of adoption? An adopted child shall be deemed to be a child of his or her adoptive father or mother for all purposes, with effect from the date of the adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be severed. Severed means they are cut off from his natural family and replaced by those created by the adoption in the adoptive family, provided that, what is important, the child cannot marry any person to whom he or she would have married if he or she had continued in the family of his or her birth. B. Any property which is wasted in an adopted child before the adoption shall continue to waste in such person, subject to the obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. See, The adopted child shall not divest any person of any estate which is vested in him or her before the adoption. So, section 13 will move on. Right of adoptive parents to dispose of the property. That is, say for example, if there are families who have taken in adoption, the adoptive parents, whether they have the right to dispose of their properties or not. So, subject to any agreement to the contrary, an adoption does not deprive the adoptive father or mother of the power to dispose of his or her property by transfer inter vivos. Now, what is transfer inter vivos? That is during their lifetime, or by will, that is after their death. But it is subject to agreement to the contrary. It means that if there is an agreement between the family from whom the child is taken and the parents who are taking in adoption, so if there is no such kind of agreement, then definitely the adoptive father or mother, they have the right to dispose of his or her property by inter vivos or by will. Section 14 speaks of determination of adoptive mother in certain cases. Where a Hindu who has a wife living adopts a child, she shall be deemed to be the adoptive mother. Okay, so subsection 2 says, where an adoption has been made with the consent of more than one wife, the senior most in the marriage among them shall be deemed to be the adoptive mother and the others to be stepmother. Now basically seniority is based not on the age of a person but upon the date of marriage. So where a widower or a bachelor adopts a child, any wife whom he subsequently marries shall be deemed to be the stepmother of the adopted child. Now why that is the reason she is presumed to be a stepmother? Because at the time of adoption she was not present at, in that complete procedure of adoption. And fourth, where a widow or an unmarried woman adopts a child, any husband whom she marries subsequently shall be deemed to be the stepfather of the adopted child. Now, section 15, what does it say? Section 15 basically deals with the thing that valid adoption cannot be cancelled. What does it mean? So this adoption cannot be cancelled by the adoptive father, nor by the adoptive mother, nor by any other person, means it may be a guardian, nor can the adopted child. So what does this section basically say? That no adoption which have been validly made can be cancelled by the adoptive father or mother or by any person, nor can the adopted child renounce his or her status as such and return to the family of its birth. Section 16 provides for presumption as to the registered documents relating to adoption. So whenever any document registered under any law for the time being in force is produced before any court purporting to record an adoption made, and the same has been signed by the person giving and the person taking in adoption, the court shall presume that the adoption has been made in compliance with the provisions of this act unless and until the same has been disproved. And section 17, which has been bifurcated into 3 subsections. First, which says that no person shall receive or agree to receive any payment or any other reward in consideration of the adoption of any person, and no person shall make or give or agree to make or give to any other person any payment or reward, the receipt of which is prohibited by this section. Subsection 2 says that if any person contravenes the provision of subsection 1, he shall be punishable with imprisonment, which may extend to 6 months, or with fine, or with both. And subsection 3 says that no prosecution under this section shall be instituted without the previous sanction of the state government or any officer authorized by the state government in this behalf. So this is all about section 11 to section 17 of Hindu Adoption and Maintenance Act 1956. So with this, I say thank you.